Hello, good citizens. My name is Dan, and welcome back to the Victoria Crown Prosecutors Lies and Crime series. This is the conclusion, Part 7. So in July 2017, after listening to the DARs and ordering transcripts, I filled out the paperwork to have Mr. Pugh, Paul Jeffrey Cheeseman, Melissa R. Murray, and Lauren T. Phipps criminally charged for their criminal actions on the court record. Specifically, I swore and signed the forms to have Mr. Pugh charged with 1 count each of perjury, public mischief, fabricating evidence, obstructing justice, and criminal harassment, as well as the 3 Crown prosecutors, Paul Jeffrey Cheeseman, Melissa R. Murray, and Lauren T. Phipps, each charged with 1 count each of fabricating evidence, obstruction of justice, and criminal harassment. This is called a private prosecution, and I was given a court date to show up to fix a date for a process hearing. Now, I've been through this before when I tried to have a police officer named Alex Yelovats of the CRD IRSU criminally charged after he criminally assaulted me. In going through this process, it was obvious that the criminal justice system is set up to not only investigate themselves through their own connected agencies, but to also clear themselves of any wrongdoing through their own connected agencies with zero independent oversight. The charge of assault that I tried to put forward against Officer Alex Yelovats never even got before a judge as described by the Criminal Code of Canada via a process hearing. And in speaking with Senior Crown Prosecutor Ken Madsen on how it's possible that when there's evidence of an assault on me by a police officer, that charge got dropped before it could even get before a judge, and I'm being prosecuted for the same offense in where no evidence exists. Ken Madsen kept fumbling over excuse after excuse in a recorded call, making a complete fool of himself and bringing our justice system into disrepute. That phone call was posted a while ago, and there's a link to it in the description. If you haven't heard it, you should check it out. So after reading Crown Counsel policy on private prosecutions and in dealing with Ken Madsen, I was now better prepared to deal with these new charges. I received a phone call from Detective Constable Ian Hines of the Victoria Police Department, and Constable Hines wanted to interview me regarding these new charges. And in a recorded phone call, I discussed with Constable Hines that, according to Crown Counsel policy, they generally do not allow private prosecutions to proceed, something he was not aware of and seemed to have an issue with understanding. Constable Hines tried to give me the bait and switch routine, but it wasn't going to work on me, especially after I pointed out to him that according to Crown Counsel's own policy, this was not appropriate. And I explained to him that I'd be happy to do an interview with an agency not connected to the Victoria Crown Prosecutors or the Victoria Police Department. That phone call was posted a while ago, and there's a link to it in the description. If you haven't heard it, you should check it out. On the day of the court date, to fix a date for a process hearing, Vancouver criminal defense lawyer Gail Barnes appeared in court on this matter as ad hoc Crown Counsel. That's when a lawyer with a private practice steps into the place of a prosecutor. This can happen for a variety of reasons. This is what I call a rent-a-crown. As the matter was called, I spoke on my own behalf, and making it painfully obvious, Gail Barnes was clearly not happy about being appointed this position. I'm guessing she didn't have time for this, and coming from Vancouver, this essentially wasted a day of her life where she could be charging some poor sap $6,000 a day in court. Either that or she's got a tall stack of legal aid cases that she can barely keep track of, and her assistant probably does all the work for her just so she can stay afloat. We eventually set a date for a process hearing, and approximately 3 business days before the process hearing, Gail Barnes sent me the following letter.
Whether the charge approval standard was met in relation to the allegations contained in the informations, I reviewed the transcripts of all relevant court proceeding for the substantive charge. I have also reviewed all transcripts for the breach. I have also reviewed material provided by Detective Constable Hines of the Victoria Police Department. The matter was referred to him pursuant to Crown Counsel Policy Pre-1 for his agency to decide whether to investigate and prepare a report to Crown Counsel. Detective Constable Hines contacted you on July 18, 2017 in an attempt to obtain a statement from you as part of his investigation. His report indicated that you told him you would not be providing a statement to him. Consequently, apart from the transcripts of the court proceedings, which revealed no evidence to support any of the charges in the private informations noted above, there was no other evidence on which any of these charges could be supported. As a consequence of my decision to enter a stay of proceedings on each of these charges, there will be no further proceedings in respect of the informations that you have sworn. Yours truly, Gail Barnes.
So Gail Barnes basically concluded that because I would not speak to Constable Ian Hines, and according to her, the transcripts did not provide any evidence to support any of the charges that I had laid against Mr. Pugh, Paul Jeffrey Cheeseman, Melissa R. Murray, and Lauren T. Phipps. Now hang on a sec, because I know what you're thinking, right? How can there be no evidence, right? Well, hang on. Let's give old Gail Barnes the benefit of the doubt, and let's go over how the criminal code defines each charge, and see if we can match them up with either something like evidence in the transcripts or something that could be given by me if I was given the opportunity to be interviewed as per Crown Counsel's own policy. And we'll start with perjury, section 131 of the Criminal Code. Everyone commits perjury who, with intent to mislead, makes before a person who is authorized by law to permit it to be made before him a false statement under oath or solemn affirmation, by affidavit, solemn declaration, or deposition, or orally, knowing that the statement is false. Public mischief, section 140 of the Criminal Code. Everyone commits public mischief who, with intent to mislead, causes a peace officer to enter on or continue an investigation by A, making a false statement that accuses some other person of having committed an offense, B, doing anything intended to cause some other person to be suspected of having committed an offense that the other person has not committed. Fabricating evidence, section 137 of the Criminal Code. Everyone who, with intent to mislead, fabricates anything, with intent that it shall be used as evidence in a judicial proceeding, existing or proposed by any means other than perjury or incitement to perjury, is guilty of an indictable offense and liable to imprisonment for a term not exceeding 14 years. Obstructing justice, section 139, subsection 2 of the Criminal Code. Everyone who willfully attempts in any manner other than the manner described in subsection 1 to obstruct, pervert, or defeat the course of justice is guilty of an indictable offense and liable to imprisonment for a term not exceeding 10 years. And basically what that says is it's to be open to interpretation. Criminal harassment, section 264 of the Criminal Code. No person shall, without lawful authority, and knowing that the other person is harassed, or recklessly as to whether the other person is harassed, engage in conduct referred to in subsection 2 that causes the other person, reasonably, in all the circumstances, to fear for their safety or the safety of anyone known to them. And just to clear up the subsection 2 says this: the conduct mentioned in subsection 1 consists of A, repeatedly following from place to place the other person or anyone known to them. B, repeatedly communicating with, either directly or indirectly, the other person or anyone known to them. C, besetting or watching the dwelling house or place where the other person or anyone known to them resides, works, or carries on business or happens to be. Or D, engaging in threatening conduct directed at the other person or any member of their family. So let's start with Mr. Pugh, and we'll start with count 1, perjury. And just going by the DARs and the official court transcripts, and I'm going to be very specific or verbatim. Quote, where I lived at the time, unquote. Quote, lived, unquote. Quote, lived, unquote. Quote, I lived on Uphill Avenue, unquote. Quote, there's a garbage can right outside the building I was living at the time, unquote. And when Judge Rogers asked Mr. Pugh if he was comfortable talking about where he lived at the time, he replied, quote, yep, unquote. So obviously Mr. Pugh intended to mislead, and he made the false statement knowing that the statement is false. And we know this is false because Mr. Pugh later had me arrested and imprisoned and charged with breach of recognizance for being on the property in which he no longer lived at, or so he says. Let's move on to count 2, which is public mischief. Well, Mr. Pugh did commit public mischief in that with the intent to mislead the Victoria Police to enter upon an investigation by A, making a false statement that the accused, me, of having committed the offense of breach of recognizance, and that Mr. Pugh reported the offense of breach of recognizance when that offense had not been committed. When I was originally placed on the bail conditions, they said that I cannot go where I know he lives. Mr. Pugh would have also received a copy of that, and it would have been verbally read to him over the phone by my bail supervisor. So Mr. Pugh knew exactly what he was getting himself into. Let's move on to fabricating evidence. So Mr. Pugh did, with intent to mislead, fabricate statements to police about me committing the offense of breach of recognizance, as well as failing to tell the police that he gave misleading testimony on the record the previous day at the trial in the Victoria Law Courts. And Mr. Pugh gave all this information to the police with the intent that it should be used as evidence in a proposed judicial proceeding. Let's move on to count 4, obstruction of justice, attempt to pervert, defeat, or obstruct justice. So Mr. Pugh did willfully attempt to obstruct, pervert, and defeat the course of justice in a judicial proceeding by having me arrested, imprisoned, and charged with the offense of breach of recognizance on contradictory testimony on the record given by Mr. Pugh in the trial. And count 5 is criminal harassment. And Mr. Pugh did criminally harass me by knowing that I was harassed or reckless as to whether I was harassed, and did so without lawful authority by engaging in threatening conduct directed at me, thereby causing me to reasonably, in all the circumstances, fear for my safety. So when someone calls the police on you just to have you arrested because they're pissed off at you, is that threatening conduct? And you tell a big spun up story to have them held in custody for God knows how long. Is that threatening conduct? You tell me. And am I reasonably fearing for my safety by being in prison for something I couldn't have done and I have no criminal record? And let's move on to the 3 prosecutors. We'll start with Paul Jeffrey Cheeseman with count 1, fabricating evidence. And Paul Jeffrey Cheeseman did, with intent to mislead, fabricate statements and or submissions about me, committing 1 each of breach of recognizance, criminal harassment, and obstruction of justice, as well as failing to tell the judge at the trial, which Paul Jeffrey Cheeseman was present in, Mr. Pugh, the complainant, misled the court that he had moved and no longer lived at Ding Ding O Ding Uphill Avenue, thus changing the conditions of the accused own recognizance and specific bail conditions, with the intent that it should be used as evidence in a proposed judicial proceeding. And you may remember when Mr. Kuzma was acting as duty counsel on my behalf, and Mr. Kuzma stated to the court that he had spoke to Mr. Cheeseman, and Mr. Cheeseman had a recollection, but that wasn't my recollection. So, as I said in part 6, if Mr. Cheeseman had only been honest about this, probably none of this ever would have happened. And count 2 for Paul Jeffrey Cheeseman is obstruction of justice. That's the attempt to pervert, defeat, or obstruct justice. And Mr. Cheeseman did willfully attempt to obstruct, pervert, and defeat the course of justice in a judicial proceeding by suppressing evidence on the record, which was on the DARS, causing me to remain in custody while the DARS from the assault trial, which Paul Jeffrey Cheeseman was present in, proves multiple times that I could not have committed the offense of breach of recognizance, criminal harassment, and obstruction of justice. Count 3, criminal harassment. And Paul Jeffrey Cheeseman knew that I was harassed, or was reckless as to whether I was being harassed, did, without lawful authority, engage in threatening conduct directed at me, thereby causing me to reasonably, in all the circumstances, fear for my safety. So if somebody had knowledge of evidence, and they suppressed that evidence in order for you to remain in prison, is that threatening conduct? Would you fear for your safety? And also in subsection 1 of criminal harassment, this also applies as well. It says that the other person reasonably, in all of the circumstances, to fear for their safety or the safety of anyone known to them. And I certainly feared for the safety of my spouse after a couple of days in prison. She was all alone, and when it got to the point after a couple of days, I'm now legitimately fearing for her safety because I'm not there. I'm not home, and if something happens, or say somebody breaks in, this was something I was fearful of. just being away for the first couple of days. And literally, every hour that goes by, my fear for her safety increases. So imagine how extremely terrified I am after being in prison for 2 weeks, and she's been all alone this whole time. And if I plead not guilty, then I'd be in prison for at least 6 more months, or possibly a year. And that's one of the main reasons why I pled guilty. And that does fall under criminal harassment. And let's move on to Melissa R. Murray. So Melissa Murray did, with intent to mislead, fabricate statements and submissions in a bail hearing about me, as well as failing to tell the judge that Mr. Pugh, the complainant, misled the court that he had moved and no longer lived at Ding Ding O Ding Uphill Avenue, thus changing the conditions of the accused own recognizance and specific bail conditions, with intent that it should be used as evidence in a proposed judicial proceeding. Now, it might be arguable that Melissa R. Murray didn't actually say anything to the judge. The judge just said, hey, the court time's over for today, so you're going to prison for the weekend. That she didn't fabricate evidence, but she also had knowledge of evidence that should have been brought forward, or at least considered. And because Melissa R. Murray failed to do that, then that's what she's relying on. She is relying on evidence that is fabricated. Simple as that. Count 2 for Melissa R. Murray is obstruction of justice, the attempt to pervert, defeat, or obstruct justice. And Melissa Murray did willfully attempt to obstruct, pervert, and defeat the course of justice in a judicial proceeding by suppressing evidence on the record, the DARS, causing me to remain in custody while the DARS and the transcripts from the assault trial proves multiple times that I could not have committed the offense of breach of recognizance, criminal harassment, and obstruction of justice. And count 3 for Melissa R. Murray was criminal harassment. And Melissa R. Murray knew that I was harassed or reckless as to whether I was harassed, did without lawful authority, engage in threatening conduct directed at me, thereby causing me to reasonably, in all the circumstances, fear for my safety. So again, when someone has evidence and they suppress that evidence and they use the courts as a weapon and they're having you held in prison for something that they know you couldn't have done, you tell me, is that threatening conduct? And am I reasonably fearing for my safety by being in prison for something I couldn't have done and I have no criminal record? Lastly is Lauren T. Phipps, and count 1 for Lauren Phipps is fabricating evidence. And Lauren Phipps did, with intent to mislead, fabricate statements and submissions about me committing 1 count each of breach of recognizance, criminal harassment, and obstruction of justice. Lauren Phipps misled the judge at the bail hearing on the record that while I was in a reverse onus position, that the version of events that I was putting forward to the court is contradicted by the DARS, as well as Lauren T. Phipps failing to inform the bail hearing judge that Mr. Pugh, in the assault trial, misled the court that he had moved and no longer lived at Ding Ding O Ding Uphill Avenue, thus changing the conditions of the accused's own recognizance and specific bail conditions, with intent that it should be used as evidence in a proposed judicial proceeding. Count 2 for Lauren T. Phipps is obstruction of justice, the attempt to pervert, defeat, and obstruct justice. And Lauren Phipps did willfully attempt to obstruct, pervert, and defeat the course of justice in a judicial proceeding by suppressing evidence on the record, the DARS, causing me to remain in custody while the DARS from the assault trial proves multiple times that I could not have committed the offense of breach of recognizance, criminal harassment, and obstruction of justice. And count 3 for Lauren T. Phipps is criminal harassment. And Lauren Phipps knew that I was harassed or reckless as to whether I was harassed, did without lawful authority, engage in threatening conduct directed at me, thereby causing me to reasonably, in all the circumstances, fear for my safety. So when I go to that bail hearing in part 4 and tell my side of the story, which was the truth, and Lauren tells the judge that the DARS, the audio recording from that part of the trial, the assault trial, contradicts my story when it actually supports my story, so that Lorne Phipps could have me held in prison for an offense that I could not have committed in an act of retaliation. You tell me, is that threatening conduct? And having me held in prison with no criminal record for an offense that I could not have committed? In all of those circumstances, would I fear for my safety? So there's that. Now, here's an interesting point. How can Gail Barnes say there's no evidence? Remember in Part 6, my no evidence motion with Judge Rogers? According to Judge Rogers, by Mr. Pugh saying I punched him, that is some evidence. So if I say that 3 prosecutors and Mr. Pugh fabricated evidence and obstructed justice and criminally harassed me, and Mr. Pugh committed perjury and public mischief, isn't that some evidence? Right, because Judge Rogers said if Mr. Pugh says I punched him, that's all the evidence she needs to get a conviction. Then shouldn't it be the same for me when I file all the paperwork and say that they did all that? Isn't that some evidence? Because it sounds like Gail Barnes is contradicting Judge Rogers, and Judge Rogers is contradicting Gail Barnes. In fact, both of them are discrediting each other, aren't they? And it also should make you wonder, how did the assault charge get approved with no tangible evidence? Just on somebody saying that I punched them. So how does that get approved when, according to Judge Rogers, the only evidence that you would need to convict somebody of assault is somebody claiming they were punched? So how can that assault charge even get approved, and then me filing charges against 3 prosecutors and Mr. Pugh, that all got dropped even though there's solid evidence in the transcripts? And how could she say that the charge was also stayed as a consequence of me not providing a statement to a connected agency? According to their own policy, that's not appropriate. If I give a statement to a connected agency, it's guaranteed to go nowhere. That's just a normal and accepted dysfunction of our justice system. So maybe Gail Barnes never actually read the transcripts, as she claims she did. Or maybe what really happened with that, which is all too common with lawyers, is Gail Barnes had her assistant read it for her. Well, maybe her assistant started and fell asleep after the first page. Or maybe her assistant is so bogged down with a tall stack of legal aid cases that are her assistant's responsibility, the assistant never had time to read the transcripts. Isn't a tall stack of legal aid cases a tall stack of money? Well, maybe that's what happened. Because there's no money to be made here with me in my matter, right? So maybe I'm just wasting the time of the moneymakers. Oh, sorry, moneymakers. Now I know how the justice system really works. And so do you. Yes, you watching this. Speaking of which, leave a comment below about how you think Vancouver criminal defense lawyer Gail Barnes handled this matter. What kind of service would you get from a criminal defense lawyer that can't recognize when Crown witnesses are committing perjury, public mischief, fabricating evidence, obstruction of justice, and criminal harassment? And what kind of service would you get from a criminal defense lawyer that can't recognize when Crown prosecutors are committing fabricating evidence, obstruction of justice, and criminal harassment? Would you hire or recommend a criminal defense lawyer that can't find any evidence in clear cases of legal abuse on the court's own record? Look at all the evidence that I pulled out of the transcripts. I'm just a buffoon that could barely put together a grade 12 education, but Gail Barnes is a full-blown lawyer and can't find any evidence in the transcripts? I'm guessing that maybe some criminal defense lawyers aren't as good as they say they are on their own websites. It does pay to shop around, I know that. Well, what an embarrassment to our justice system, our province, and our country. Shame on you, Gail Barnes, for allowing this to happen without any consequences, for making our courts look like a joke. Now, I did email BC's Attorney General, David Eby, as he is responsible for the conduct of British Columbia's Crown prosecutors. Surprisingly, Mr. Eby never responded. Shame on you, Mr. Eby. How can you sit by idly and let this matter in which you're responsible for get not only this far, but completely evade accountability and bring disrepute to our justice system? Well, I'm going to wrap Part 7 and the entire series up right here. Thanks for watching. Thanks for sticking with me. I know it's been a long haul, Parts 1 through 7. I hope you watched them all. And just a quick update. As of this recording, in late June 2018, the punitive and therefore unlawful probation conditions of the anger management and violence prevention counseling that I was forced to take made no improvements to rehabilitate me. I was not an angry or violent person before the counseling, and I still am not today. So clearly that condition was unlawful because it didn't contribute to my rehabilitation and it didn't contribute to protecting society. And the same goes for the restrictions of using video and audio recorders on people without their consent. I got into photography and making short films in 2010, 5 years before all this started, and I'm still doing it to this day. Therefore, clearly that order was unlawful because it didn't do anything to rehabilitate me, and it played no role in protection of society. Thanks for watching.